Roy Baharad from the University of Chicago, where he's an SJD student in the law school, is going to be talking about reliability insurance, and the usual game plan applies. So Roy, the floor is yours, and when you're done, let me know, and we can just move to the questions.
Excellent. Just let me know if you can see the slides.
Yep, the slides, look, they're showing up, except that one's blank.
Yeah, sure. Oh, and I'll share just the audio maybe. 1 second. Yeah. Okay. So hi everyone. It's great to be here, and thank you so much for the invitation. My name is Roy. I'm a doctoral candidate at the University of Chicago Law School, and this project is part of a series of papers where I'm basically studying the interaction of insurance with I'm studying the interaction of insurance with information economics, and what the presence or absence of insurance signals to third party, and how third party would subsequently react. And let me just start with a simple motivating example. So we have Anne. Anne is a journalist. She publishes an article against Bob, who is a senior government official. She accuses him of corruption, of accepting a bribe. Bob, in turn, is upset. He files a defamation suit against Anne. And now consider two scenarios. In scenario A, Anne is insured against liability for defamation, and in scenario B, Anne is uninsured. And just ask yourself, under which of those scenarios you would consider Anne's publication to be more credible. So you might have contradicting intuitions. Stephen Colbert thinks that the answer is obvious.
Because yesterday, Fox News settled Dominion's defamation lawsuit for $787.5 million. This is a huge hit to Fox's bottom line, although it's not clear if insurance will cover some of Fox's liability. Of course, Fox has to have liability insurance to ensure their ability to lie. Although...
Okay, so actually he has a point. So just the structure of the structure of the talk. I'll start by describing the theoretical conceptual framework. I'll then like the objectives of tort liability, specifically its informational function. Then I'll study its intersection. I'll talk about its intersection with liability insurance. Then sort of the mapping on how insurance can affect reliability. I'll discuss some case studies. The article discusses them more, and then case studies are professional liability insurance, medical malpractice, and legal malpractice. Then employment practices liability insurance, and also defamation liability insurance. I reserve the right to skip this one, depending on how much time we've got. And then I'll try to ask a more fundamental question on why this discussion is even important, specifically to the study of risk externalities by insurance, incentives to exercise care, and risk distribution more generals. And I'll conclude with some lessons to insurance scholarship maybe. So tort liability, customarily when we think of tort liability, two immediate associations: it's deterrence of potential injurers, and tort liability also assures compensation to victims. Tort liability actually has a third function, which is credibility. Like, liability establishes reliability in the eyes of potential counterparties or potential victims. And the thing is that while deterrence and compensation are studied from like victims' perspective, the advantage victims. The credibility function means that tort liability actually advantages injurers, and the reason is simple. It's a tort liability is basically a commitment to incur the cost of an unreasonable risk, right? So it guarantees that injurers actually have a skin in the game, which strengthens trust. So we may think of, I mean, many interactions, right? The fact that doctors will be held liable for malpractice increases the reliability that patients ascribe to them. Investing in a you'd probably prefer to invest in a company where executives are actually liable for taking unreasonable risks. Employees, other interaction, journalists, for example, right? So recall the Ann Bob example. The fact that there is liability for defamation on false statements increases the credibility of Ann's statement, because this is basically an obligation to pay damages in case that her publication is proven false. Also, contracting parties, right? The fact that I may be liable for misrepresentation during negotiations will increase the credibility of the information that I am conveying to counterparties, right? Pretty straightforward, nothing particularly groundbreaking here. Now, let's add liability insurance into the picture. So we understand that liability implies that it creates internalization of the cost of risky behavior by insurers, and therefore it establishes reliability in the eyes of counterparties. But if we incorporate insurance into the picture, what happens in insurance? Actually, it's the obverse scenario, right? Insurance transfers the cost of risky behavior onto the insurer. So now the question is whether it implies unreliability or whether it undermines the credibility function that tort liability can provide injurers. And the question is, again, whether would you prefer to, I mean, we can discuss it in concrete questions. Would you entertain ourselves with these hypotheticals? Would you prefer to be treated by an insured or uninsured physician, to invest in a company with enhanced or limited D&O insurance? Would you ascribe more credibility to Ann's publication in the previous example? Working, would you prefer applying for a job when the employer is insured or uninsured against liability for overlooking sexual harassment or any other type of discrimination in the workplace, or contracting with a counterparty that is or is not insured against misrepresentation? So this is the general question, and now let's establish the theoretical background on how can insurance actually affect reliability. A lot of moving parts, and the baseline here, and the baseline question is whether insurance actually implies whether, I mean, the fact that my counterparty is insured actually implied that he's more or less risky. So it divides to two other parts. There's the classic approach that insurance is a social construct that basically increases risk in society. Two main reasons, right? First, it creates perverse incentives once acquired, right? Because if I'm an insured driver, then I have less incentives to exercise care. This is the classic moral hazard problem. We also have the ex-ante problem of adverse selection, where insurance is especially valuable for those who need it, right? For individuals of riskier type, and therefore those individuals will opt into insurance. So this means that the signal of insurance basically is a signal of increased riskiness. On the other hand, there's the modern approach that perceives insurance as a quasi-regulator, right? The insurance as governance. Again, along these two dimensions, first, insurance creates optimal incentives by exposed by consistently monitoring and guiding insureds and adjusting risk premiums to policyholders, and thus it consistently work to mitigate the moral hazard problem. And against the adverse selection, we also have the much underappreciated phenomenon of propitious selection. Propitious selection means that insurance might attract risky individuals, but for the most part, it simply attracts cautious individuals. So to exemplify propitious selection, I typically give the example of my parents, who always purchase flight cancellation insurance and also show up at the airport like 5 hours before. Right? So those are thanks, Peter. Yeah, and Peter wrote a lot about propitious selection. And again, if we account for this approach, then insurance might be perceived as actually the presence of insurance is a stamp of good conduct and of prudence. Now, there are other considerations beyond riskiness that might impact the attractiveness of interacting with an insured or an uninsured agent. The first is solvency. So interacting with insured parties might be preferable, even if they are riskier, because counterparties, might be judgment proof. And in this regard, we may say that even if insurance increases the risk that I'm about to suffer any harm, insurance still makes sure that I will be able to be adequately compensated for this harm. So in terms of the trade-off, I might be still better off with interacting with an insured individual. But on the other hand, exactly because insurance induces like policyholders to avoid risks and avoid lawsuits and take all the necessary means to avoid it, the interacting with insured parties might actually not be preferable because it might imply overprudence. I'll discuss it momentarily when I address medical malpractice insurance. But broadly speaking, this is the map. This is a conceptual framework that serves as a guideline. And then in the paper, I turn to discuss like concrete industries. And now let's like touch upon some of them. Okay, so first, professional liability insurance. In medical malpractice literature, there's voluminous literature on medical malpractice insurance, and that has actually recognized all of those effects, right? So first, there's evidence on how insurance ensures solvency, because otherwise doctors couldn't pay for harms they create, they cause off their own pocket. We also know that insurers monitor and regulate the riskiness of physicians and treatments, actually so much so that the Physician Insurer Association has recently rebranded and is now termed the Medical Professional Liability Association, just to emphasize its like regulatory role, regulatory function. There have obviously been concerns for moral hazard on the other hand, which implies excessive risks and increased risk to suffer harm, and evidence on actually that monitoring insurance monitoring is a core contributor to overprudence and defensive medicine among physicians. So there's I'm citing there a nice New York Times piece about a decade ago on hospitals that decide to go bare, that decide to provide to forgo insurance, and there are like two competing explanations. So first, the undertone is critical because it might sound like an opportunistic decision to of hospitals to self-impose like insolvency and simply declare lawsuits. But within this article, there's also the argument, the obverse argument, and the argument is that because juries like award exorbitant damages if negligence is found, then risk premiums do not actually reflect the expected loss caused by a medical treatment. And for this reason, hospitals basically confront the trade-off of, basically confront the dilemma of paying excessively for insurance or save those costs, and with those costs, like provide better treatments, like hiring more nurses and so on. So, and there's a, by the way, similar scholarly discussion on insured lawyers, although the literature is much more narrow in this regard. So in conclusion, here the effect of reliability is really, I mean, equivocal, because we can't say much because there's evidence that go either way. Another industry, employment practices liability insurance. It covers, mostly covers management's liability, the upper management's liability for failing to address prominently sexual misconduct, but basically any other form of workplace discrimination. There's a great Erin Miles and Johnny Hirsch piece at Cornell Law Review on this industry. And what's interesting is that the enforceability of such agreements is debatable at the outset. And the reason is that those agreements also cover cases where the upper management was aware of misconduct, but quite overlooked it. And why is this potentially unenforceable? Because we know that insurance insurance contracts that govern intentional behavior are mostly invalid. And an example is the Weinstein Company. So it was widely known within the Weinstein Company. Harvey Weinstein's repeated sexual assault and his behavior was widely known within the company, but has still been overlooked. And the actually insurance company is the one that paid the settlement, in the class action. This settlement has later been rejected by courts for other reasons. But what's the main takeaway for the purposes of our discussion is that the fact that such agreements are debatable result in insurer favorable settlements, right? Because the insurer there's always the fear, the plaintiff's fear that the court will invalidate the insurance agreement, and then the plaintiff will confront a judgment-proof injurer. So this allows the insurer to extract rather favorable settlements. Now, what's the main conclusion in terms of information? In terms of, would we prefer to work for an insured or an uninsured employer? So the incentive to monitor, insurance incentive to monitor, according to Mayers and Hirsch, actually are lower because of their increased bargaining power, namely because they confront a lower expected loss. And if you confront a lower expected loss, then you have a lower incentive to eliminate this loss. Second, that insurance actually ensures solvency in this regard, sure, but this advantage is again eclipsed by the settlement leverage, by the constant threat that the contract will be ultimately invalidated. Also, so overall, it seems that insurance here undermines reliability, but still, in this case, it trades off riskiness. Okay, it perhaps increases the risk of loss here, but it ensures compensation to each victim. So again, this is a trade-off in terms of like normative policy responses. Finally, let's touch upon how are we on time? Are we good, Peter?
Yeah, you can take as much time as you want, really. It's only 20 after 4, so you got another 15 minutes for sure if you need it.
Okay, excellent. Thanks. So just touch upon defamation liability insurance. It is actually, there is zero, to the best of my knowledge, zero academic literature on defamation liability insurance, which is interesting, because fascinating, because this is a really interesting topic. So this is reportedly widely prevalent among media outlets, not only Fox News, actually ABC News once settled with Disney in a defamation case, and an insurance company paid the settlement. Also, when CNN covered the Fox case, they were honest enough to say that, yeah, actually, that's normally the case. It's regular it's typical for news outlets to have defamation insurance. And the question here is, again, whether it undermines the credibility of publication. So on the one hand, we say, sure, because defamation liability increases credibility. It makes defamation liability. There is a great paper by Ariel Porat and Daniel Hamel on, well, without defamation liability, like any statement I would make would be cheap talk, right? It would mean nothing in the world. But with defamation liability, it turns into a signal, because again, it's basically a commitment. It's basically my commitment to pay damages if my statement is ever proven false. What's interesting is that with insurance, the problem of cheap talk basically resurfaces, right? Because I'm not the one incurring the cost of damages in case that my publication is proven false. So intuitively would say that yes, undermines credibility. On the other hand, if we have this proactive insurer who is a quintessential regulator, and it adds another regulatory layer, then sure, monitoring could enhance credibility of publication of statements that are published, but socially speaking, it may actually set too stringent standards, and there isn't total evidence on journalists that wanted to that actually had to forgo publications in order to maintain their insurance policy. And so again, insurance here could exacerbate the chilling effect that First Amendment scholars are routinely associating with defamation law. And again, evidence is inconclusive, and the paper does more. It reviews more insurance industries, and that's it. And in the article, I have a normative discussion concerning the implications. How can we use regulatory devices in order to maximize or extract the informational value of insurance? But here I actually want to take a step back and discuss the conceptual importance of this idea. And a second, okay, of this idea, and I think it would be best to present it in the following way. So, brief insurance literature traditionally focusing on interactions, on the bilateral interaction between insurer and insured, all in terms of risk distribution and incentives to exercise care. So we have this 50s, 60s, 70s, mostly economic articles that focus on, that address the problem of moral hazard, right? Insureds do not have sufficient incentive to exercise care, and thus they externalize the cost of their the risk on insurers. Afterwards, I mean, economists kind of allude to insurance's governance. For example, Chavel's, I think, 1979 model in the QJE accounts for the possibility that care is in fact observable, and the insurer could therefore react by adjusting premiums. But it has been studied thoroughly and in terms of concrete industries, mostly by lawyers and by legal scholars and public policy scholars, beginning in the 2000s, I think. So Kenneth Abraham, Weben Shachar, Kai Laug, and many others come up with the idea of insurance as governance, which means that basically the insurer, by monitoring, training, etc., can force the insured to re-internalize the cost of the risks that they create. Fast forward 2022, Peter Sigelman and Gidon Polkomowski in a truly groundbreaking paper introduce third parties, incorporate third parties into the equation, and they show that third parties too can externalize risk, can and will externalize risk onto insurers because there is like another deep pocket player that can incur the cost of risk taking. So and this is the picture I think right now in the literature. Now consider now incorporate the fact that some third parties could be deterred by the fact that their counterparty is insured. So, for instance, so there's a debate in the insurance literature on whether police misconduct insurance exacerbate or reduces the problem. There's the Joanna Schwartz piece and NYU that says that police misconduct indemnification might result in moral hazard. And there's the John Rappaport paper at Harvard Law Review that says that no, actually, insurers do quite well at training and reducing the pervasiveness of police brutality, police misconduct, but take the example and suppose that insurance exacerbates the problem, and as a result, many people just avoid areas with police and avoid those kind of interactions. In this case, we have third parties that are ultimately incurring the risk, right? By increasing their prudence. Okay, so I might, in the example of police misconduct, for example, if there's a third party that takes another path, walks through another path, that drives another route in order to avoid any encounters with police. This is an example of third parties that might change their behavior and ultimately be the ones bearing the risk. Another example in the transactional case, so D&O insurance, for example, there's a large literature on how increased D&O insurance results in lower stock prices or and general like skepticism by investors, and this means that investors can actually punish ones who are excessively insured, and in this case, again, they are redisciplining the insureds and make it necessary for them to signal their prudence and again re-internalize the risks that they create. Another relevant reaction here is by insurers, right? When insureds could externalize their take driving, okay, as a perhaps more as a easier example. Suppose that an insured driver is more risky, and you as a third party simply to take this, and of course it's toy style as example, just consider it to get the gist of the idea. And you as a third party avoids driving or lower your speed and takes care and increases your level of care basically in order to reduce the riskiness and avoid risks and avoid loss. Even in that case, even if the insurer can effectively monitor the insured, it has no real incentive to do so because third parties are the ones that actually exercising care, right? So this means it implies insurer moral hazard because the insurer can take care but avoids doing so because he knows that the loss will be suffered by another party. So basically externalizes the cost on third parties. By the way, another relevant example is D&O insurance. Tom Baker and Sean Griffith has a book on whether D&O insurance actually serves as a regulator and as a means of governance and manages to discipline D&Os, and they conclude that it does very little. And a possible explanation is that the market already reacts. I mean, the market punishes increased or the market could punish excessively insured D&Os, and in that case, insurer might be reluctant to take optimal care in monitoring insureds because he knows that third parties and insureds are that the risk is basically divided between insureds and third parties. So takeaways: the analysis of third-party reaction to insurance might be more complex than previously thought and more complex than currently portrayed in the literature. Another insight is that actually any party among this triangle, right, of insured and third party, may exhibit moral hazard and exercise insufficient care, and any party may ultimately be the one who actually bears this excess risk. And a general equilibrium approach is actually required to realize which party would actually incur the cost of the risk. That's it. Thank you so much, and I'm really looking forward for your comments.
Wow, thank you. There's a lot there. Please raise your hand or send me a chat if you want to come in. Let me just start with a kind of two-part question. So the first part is, if you imagine a world in which insurance is neither banned nor required, so you have a choice to opt in, it just does not seem, we talked a little bit about this before, it does not seem like anybody is saying, hey, come to me, I'm the doctor who doesn't have insurance. Or conversely, come to me, I'm the lawyer who does have insurance when all these other jokers don't, when I'm not required to disclose that information. So what does that tell you about what people must think or must believe about the signaling value of insurance? But then the second question is, why the paper is really provocative and really, raises all kinds of fascinating possibilities, but you're very like on-off about insurance. So wouldn't I care, as the person who's interacting with the insured policyholder, wouldn't I care about, well, like what premium are they paying? Like it doesn't matter just so much that they have insurance. Are they getting a high premium reflecting the fact that these guys are really risky and I don't want to deal with them even with insurance? We would want to know, like, what's their deductible? How much skin do they have in the game? Not just whether they have insurance. So, and none of that ever seems to get disclosed, right? You can't find out. That's all private information, and it's, unless there's like a lawsuit or something, you never find out how much that is. So again, what does that tell you about the sort of market perception out there of insurance as a credibility enhancing device when we don't see it either on or off, and we certainly don't see any more fine gradations of like what premium or what risk classification or something like that?
Excellent. So again, so it depends. There's the descriptive question on whether people pay attention to insurance or not, whether it is actually a consideration day-to-day conduct. And the answer to this is is pretty straightforward. The disappointing is, well, sometimes it does, sometimes it does not. And the other question, normatively, whether it should actually play a role. And I think it should. I think that perhaps mandatory disclosure of insurance will sort of help integrating it into the discourse and allow you to punish insured or uninsured. And answer that also pertains to your first comment, Peter. What's interesting to note is that even legislators do not have a cohesive perception on whether insurance undermines or enhances credibility, because, for example, when you can find disclosure rules on either direction, right? So, for example, I think that in California, if you're an uninsured doctor, you must disclose it to patients. In Florida, if you are an insured construction contractor, you must disclose it to clients. So again, the Florida legislature had perceived insurance as a bad signal that warrants disclosure, and the California legislature perceived it inversely. And the question, and another question, is whether people are sufficiently sophisticated to ask for this information. Leslie Levin has this terrific paper on disclosure duties by lawyers that go bare, that are uninsured. And in certain states, you need not disclose it directly to the client, but rather there is like a centralized registrar where you should mention there that you are uninsured, and then like clients can and then clients can go and check out whether there's an insured or an uninsured doctor. Of course, clients hardly ever do so in practice. So it depends on the level of sophistication, which obviously sometimes clients are more sophisticated, sometimes less. Counterparties. So in the capital market, you see that it prompts some reaction. But in other cases, for a host of reasons, some behavioral, we don't see it. It doesn't mean that if we were to impose a sort of a positive duty of disclosure, it will become more prevalent. That's off the top of my head.
Okay. I mean, legislatures are one thing, but presumably the actors would be. I mean, legislators have all kinds of reasons, political economy reasons for acting in certain ways or being confused or whatever. But you'd think that if there really was a strategic gain to be had by either concealing or revealing, somebody would be opting to do that. So far, I have Mark Meyerson on the queue is next, and then Francisca. I don't know if you're. Yeah. Okay. We'll get to Mark first, and then Francisca. Mark?
Great, thanks. I really enjoyed the paper. It caused me to do all sorts of scribbling, and I should indicate my perspective is that I'm a practicing policyholder lawyer for corporations. Lots of several concurrent points. One, on medical malpractice. The work that shaped my thinking is Bernard Black's book, Medical Malpractice Litigation, which is a deep study of Texas. And that's like in 2021 or something. And as I recall it, they concluded that there really was not a significant defensive medicine impact. And pervasively, they argued that the system is rigged to undercompensate victims or plaintiffs because you don't get more than the insurance, and so the doctors just reduce the policy limits to the lowest possible amount they can get away with. So your arguments were, not consistent or the same as that. So I just want to mention that book. So your paper assumes valid claims. And much of the motivation of defamation insurance, EPLI, the rest, is simply litigation expense against baseless claims, particularly, I guess, in the EPLI context. That is the employment practices liability insurance context for those of you at home. And so, I mean, I know you're creating a model, but my real world experience is the defense costs are just vast motivators of the corporate purchase of insurance. Another, I'm not going to let you respond yet, or I'm just making independent points that we're sharing. One thing is my experience with loss control is that clients rarely take up the insurers on their free loss control or discounted loss control experience. So for example, in the cyber context, it is stated that 15% of purchasers take advantage of the free or discounted pre-breach services, which means that they're even, they're a great deal, but clients don't do it. With EPLI, employment practices, I'm very cynical as a policyholder lawyer, but I think part of the reason we have the loss control, given that clients do not do uptake, is that the insurance companies didn't want the PR nightmare of indemnifying Harvey Weinstein and the like, and never having tried to avoid the losses in the first place. And I think that was a big thing at the time in the early 2000s as I was encountering it. And then the one final point and then one quick anecdote. Final point is, yeah, I think you assume price relates to exposure, which is not my experience. Price is determined more by supply and demand of insurance than actuarial risk exposure. So it doesn't work. And the last thing is the quick story of Fidelity Insurance. So when you have a service person come to your home, you see on the truck that it says bonded and insured. And that used to mean that the insurance company checked out the individual. If we go back to the 40s and 50s. But the transaction cost of doing that was too high. And so the insurance company said, we'll just cover you presumptively, and then we add exclusions. So this bonded and insured is precisely your point about reliability, but it's completely misleading and hollow because it precisely undermines what it is. So I will stop.
Wow, terrific, Mark. Thank you so much. So I'll just answer selectively, and I'll dodge the uncomfortable, because we have many points. That's the upside. The Bernard Black piece, I think are you referring to his book, or I know he has this.
Yeah, they had a book. My recollection is of the book.
Okay, because they have a Journal of Empirical Legal Studies based on the duty to settle, and I'm actually writing now on the duty to settle, but there isn't. I think you're pointing to an interesting link. I'm thinking out loud here. So I don't have an obvious. I will definitely refer to their book, but I don't have an obvious reaction. But super interesting. I was wondering whether you can say more on the cyber and the loss control. And again, obviously, like insurance's governance and the loss control method, it varies widely across one industry to another. The question is whether there are some there is a common denominator of insurers that are that do quite poorly at regulating riskiness. And what I wish to, perhaps if I'd find it, it would be great, is that these are all insurance industries where third parties actually suffer much of the damage by or operating effectively to reduce the risk, and therefore the insurance like confronts a lower expected loss and therefore have less incentive to monitor. I was wondering whether this logic applies to the cyber insurance you mentioned.
I'm quoting basically industry speeches, and I've had difficulty hectoring my own clients into taking up, the services. Maybe it's fiefdom issues or other social issues with the IT group, but
right, and the PR nightmare. And regarding your PR point, so it works both ways, right? So of course I don't want to bear the litigation costs and want that like an insurance company handle this, but when assuming that PR is part of the picture, it is quite reasonable to say that eventually the fact that I'm insured will be published, which will in turn like prompt criticism. The Weinstein Company is an example. Another example is, by the way, Bill Clinton was insured by in a defamation case, and then there's a Greta Van Susteren, Fox. There's a video of her saying, "How is it possible? What is defamation insurance?" And like a couple of years later, Fox used their own liability insurance, their own defamation insurance. So I agree. I kind of think that it washes out or works both ways. But point taken, certainly. Thanks, Mark. Thank you so much.
it's great.
Okay, I have Francisca and then Larry. Francisca, if you want, but you don't have to. But you're muted. All right, so not hearing nothing, I will, all right, can you hear me? Am I?
Yeah.
Okay, so I don't hear anything from Francisca, so Larry, why don't you go ahead?
Yeah, it's kind of fallen on, I think, what you suggested, Peter, but how are you able to distinguish the impact of insurance on riskiness and reliability from all of the other factors, from the First Amendment protections, defensive medicine is impacted by tort reform and caps. I mean, how do you measure insurance separate from all the other factors that would influence behavior?
So certainly, it's like part of the picture. But in many cases, it's I think that insurance is a game changer, at least in tort context. So I totally. So it depends on the setting, basically. Sure, so take D&O insurance. Of course, that the fact that you are insured, that you're not insured, that your D&Os are insured, it's just part of a broader picture. If I believe in your like business in vision and so on and so forth. But I think that in other cases it is more salient, and I mean, so take representation and warranties insurance. Sean Griffith has this Minnesota Law Review paper on where basically contracting parties are insuring themselves against representation and warranties. Against misrepresentation during mergers and acquisition. Don't you think that the fact that I'm insured against misrepresentation basically sets the ground? I mean, of course, this is a pivotal consideration on whether I am reliable or not. But so in some settings, I think that this is a more important consideration than in others. And in other cases, it might be yet another consideration, but one that maybe should be accounted for. I agree. I agree with your point 100%.
Thank you.
Can I ask you another one? Maybe this is, I don't know, in bad taste or something, given the current realities. But to go back to, oh, Frank, go ahead. Sorry, I don't want to hog the time. Frank Chmielewski has got his hand up.
Yeah, thank you. Can you hear me? Okay. I noticed that academics use the term moral hazard, but in the industry, as soon as we hear moral hazard, we think intent to defraud because you have insurance versus morale or attitudinal hazard, which is like passive indifference. So it's a different dynamic. You've got the fraudster versus the careless people. So it's just something I noticed. I don't know why that's done. And then I used to work in medical malpractice. So in Pennsylvania right now, a general surgeon might pay $40,000 to $50,000 a year in premiums. And it's required by law to have insurance or prove that you're self-insured. And it's wise because of the potential verdicts there are. But the fear that I think brings reliability is the fear of increased premiums. When you're already paying 50 grand, you don't want a loss because of the increased premiums. I also noticed that doctors are just conscientious. They care about their patients, most of them. And they fear being registered on the National Practitioner Data Bank. So if there's a settlement and it gets registered, various people can find that. But I think it's an ego thing. They just don't want to be on there. And I think that really leads to liability. And that's why you have the consent to settle clause, which the doctors fight against settling, versus the hammer clause, which is to counteract that. So I think that reliability often for medical malpractice often comes from the fear of premiums going up and the fear of lost reputation, which is what registering a settlement with the National Practitioner Data Bank leads to.
Right. So let me ask you this. If insurance were not mandatory, so consider another state where insurance is not mandatory. I think that, correct me if I'm wrong, there's like 6 or 7 states in which malpractice insurance is mandatory for doctors.
I don't know.
I think, and in the rest of there is no like legislative mandate, but in practice it is common to have malpractice insurance. So when insurance is mandatory, there is basically no signal here in terms of the interaction I'm looking at. The interactions I am interested in studying are whether voluntary. When insuring yourself, you're voluntarily waiving what Professor Thomas Schelling, a well-known game theorist, won the Nobel Prize, he called it the right to be sued. What do you mean, the right to be sued? But actually, the right to be sued is a right to have a skin in the game. And to bear a right to commit to bear costs in case that your behavior is proven illicit or somehow negligent. When you are voluntarily opting out of the right to be sued by purchasing liability insurance, then the sort of the reliability, the signaling issue emerges. So in case of mandatory, when insurance is mandatory, I don't have much to say in this regard. But sure, I mean,
I understand, but if you're paying 50 grand a year and a claim against you causes you to increase your premiums by $10,000-$15,000, that's a reliability factor.
I agree, and I agree with Peter. I mean, in an ideal world where there's, well, everyone is perfectly informed and there is no limits on our capacity to receive and process information, then sure, I mean, the premiums that you're paying are obviously relevant, right? Because they determine how an insurer, who is in this term is basically an information agent, assesses your riskiness. So it's like a credit score. Of course, it's relevant. So I agree completely.
We are getting close to the hour of 5. Anybody else want to come in? Maybe let me just leave you with one last one that I was starting to apologize for before. So Fox News, I mean, maybe that was just a badly chosen example, and I'll reflect my own political biases here, but I don't think Fox News is the least bit interested in signaling the truthfulness of their stories. They're interested in appealing to an audience that can generate ad revenues for Fox News, and that audience wants to hear certain kinds of things, whether they're true or not. They want to hear their views confirmed, and they certainly don't care whether they're defamatory. So, you know, I just think that, like, the signal in that context is just not important to anybody. People are not looking for non-defamatoriness of the content. They're just looking to have the content. It's like going to a movie. You know, it's like, it's not true or false. It's just a thing.
So, first, okay. So I agree with Fox, but maybe. So consider, for the example, just consider a benevolent news network. But again, this is an interesting, I mean, scenario. I'm not sure how prevalent it is in the real world, where you have an injurer, and the injurer is saying, well, basically, I don't really care whether I'm inflicting harm or not. I'm just interested in, I don't know, driving like 70 miles per hour, and the immediate question is, why would an insurer ever be willing to insure you, right? And there are insurance companies who are not in the business of losing money, and therefore they thought it would be, they're better off with insuring Fox News for whatever reason.
All right, fair enough. We have chance for one more if anybody wants, but seeing no hands, I think maybe it's time to just thank Roy for coming and for a really provocative paper. Lots to chew on and think about, and we'll be coming back to these topics in the future. Oh, wait, Francisca did want to have one last quick, go ahead. You got the last word, Francisca. Yep, there you are.
Sorry, I just wanted to do a clapping sign rather than raising my hand.
Oh, okay. Clapping
so
sign.
thank you, and
Yep.
see you in 2 weeks' time.
Oh yeah, preemption. I think Francisca is presenting right next week. Excellent paper.
In 2 weeks. All right,
In 2
so
weeks.
see you all back here in 2 weeks for Francisca's talk, and thank you again. Thanks for coming, Roy.
Thank you so much, Peter.
Okay.